Let's bring in our former federal prosecutor, Neama Rahmani, who is the president of West Coast Trial Lawyers. Neama, welcome back to The Story Is. You've been following all three of the legal cases we just talked about. Let's start with Lindsay Clancy, and let's show everybody what we're talking about in terms of her breaking down in court.
What about injuries?
All right, counsel, want me to take a break this time, all right?
All right. Jurors, close your notebooks. Place them on the chairs, please.
What kind of impact does something like that have on a jury?
Huge impact, Alex. Look, you're talking about jurors that are ordinary people. They can't help but feel sympathy for someone in Lindsay Clancy's position. She's listening to the medical examiner talk about the autopsy of her daughter. The judge had to declare
Her daughter who she killed.
Yes. So there's no doubt in my mind that the system failed her. She asked for help. She did not receive the help that she desperately needed. A lot of people think that her husband also failed her. I would never attack a grieving widower who also lost his children. But there's no doubt that she is a very sympathetic defendant. If you look at people on social media, a lot of people think that she was desperate for help, begged for it, didn't get the help that she needed. She was removed involuntarily from a psychiatric facility after trying to check herself in. She was on 12 different medications. It's going to be a tough case for the Commonwealth.
So you think that this trial is going well for her and her defense?
I think they have a shot. Normally, these type of defenses, they're dead in the water. A very small percentage of them actually succeed. But I think the more the defense is able to put the mental health system on trial and show that she was asking for help, wasn't receiving it. Now, as a lawyer, I know that's not the legal test. The legal test is, can you tell right from wrong? Are you able to conform your actions to the law? But I'm not sure the jurors are going to be able to make that distinction here with a very sympathetic defendant.
And something like this makes her feel like more of a human being instead of a monster. And
Oh,
they want to make
absolutely.
her into a monster, the prosecutors. Luigi Mangione put the headline up on the screen, looking potentially for a plea deal in federal plea deal talks ahead of a hastily scheduled hearing, sources say. Why would he want to do a plea deal, and what would that do for him?
Well, Alex, this is masterful lawyering by his defense team. Karen Friedman, Mark Ignifilo, two of the best, and this is why. It's pretty well established that parallel state and federal prosecutions, they don't violate double jeopardy. That's called the dual sovereign doctrine. Well, there's one important exception. In New York State, it's unique. New York has a law that says that a subsequent or second state prosecution can't be based on the same transaction or occurrence as a previous case. So why am I talking about this? In the federal case, the murder and weapons charges have been dismissed. They just have stalking. But if Mangione can prove that the stalking in the federal court and the murder in the state court are the same transaction or occurrence, they could potentially get the state case dismissed and just plead only to those federal stalking charges.
So that could potentially be a big deal. Where, I mean, do you think this likely happens?
It's a huge deal. Again, it's New York's double jeopardy law. Let me tell you the last time it happened, actually. It was Paul Manafort. He's convicted by a Virginia jury.
This was President Trump's campaign manager.
Exactly. And a young Todd Blanche represented Manafort in New York State Court, made the same argument successfully, went up on appeal, said, listen, you can't prosecute him twice. It was Cyrus Vance Jr., the Manhattan DA, that tried to do so, knowing that Manafort was going to be pardoned. So this argument does have some legs.
Of course, Todd Blanche, who had served as the president's personal attorney, is now the Attorney General of the United States. All right. Here in Southern California, just horrible death for Rob and Michelle Reiner, who were killed by their son. Here's the headline. New indictment alleges that Nick Reiner was lying in wait before killing parents Rob and Michelle Reiner, allegedly killed by Nick Reiner. Lying in wait, what does that term mean and why does it matter?
Well, it matters because it's a special circumstance that makes Nick Reiner eligible for the death penalty. And there's two here. The first is multiple victims, his parents, Rob and Michelle. Lying in wait is something that we're really hearing for the first time. Now, this is important because it makes him death penalty eligible, and if not, mandatory life without the possibility of parole. But it also leads to the inference that he was waiting in the master bedroom, apparently. Now, we know that he lived at the home in a guest house, but where he was when these murders happened is critical. And if he was hiding or otherwise in that master bedroom when he allegedly stabbed and killed his parents, that's a big deal.
So he's potentially in the bedroom waiting for them to show up. They get there, and then that's what happens. It's interesting. He is trying to get access to $1.5 million trust fund that his parents had set aside for him. And there's a petition for that. I want to put this up on the screen. And his lawyer says, Nick loved his parents. He is devastated by their deaths, but the facts about what did and did not happen to them are not at issue. What? What did or did not happen to them? I mean, it's alleged that he killed them. How is that not at issue?
It is the issue in the case, Alex. You're absolutely right. So California, like many states, has a slayer statute, which means that if you kill your parents, you're automatically disinherited. There's two ways for it to apply. Obviously, if you're convicted, he hasn't been convicted yet, or a probate judge can decide by a lower standard preponderance of the evidence that you did so. So him being disinherited means that he'll probably have to go with a public defender and not celebrity lawyer Alan Jackson.
And by the way, you said that this was taken to a grand jury, which almost never happens, as a way to potentially stop people like Conan O'Brien and others from having to testify at a preliminary hearing, but they could be testifying at a murder trial if that comes. Neama Rahmani, thank you so much for being with us. We appreciate it.